112. All right, we are on record this afternoon on petition 2 in this file. I have given the attorneys time to chat and time for the attorneys to chat with their clients. And I understand that we are ready to proceed. May I have appearances, please?
Lee Heiss, lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department.
Chelsea Pelham Reeves on behalf of the department.
Michael McFarland representing father.
Aaron Foote. Michael Brooks, I represent the mother, Mrs. Foote.
Pamela Foote.
All right, Chelsea, what did you say your last name was?
Pelham Reeves.
Can you spell, please?
Pelham space Reeve.
Thank you. R-E-E-V?
V-E.
3 E's?
I'm sorry, Reeve. So yes, 3 E's total.
Okay. Thank you. All right. Got it. Okay. All right. As it relates to the preliminary hearing basics, gentlemen, I think we've been through this before because we are here on petition 2, but could you confirm whether or not we have each parent has received the petition, whether or not there's Native American heritage, other cases that may affect today's hearings?
Client has received petition, no Native American heritage, no other cases. We are prepared to enter a plea.
Have you received a copy of the petition?
Yes, sir.
Is there any Native American heritage?
No, sir.
What was the third one?
What we're doing.
And whether or not there are any other cases that could affect the custody.
Are there any other cases that would affect this case? Like in circuit court?
I was gonna say the only one would be Mikey's probation.
The oldest boy is on probation for various criminal activities and has other criminal activity charges pending in juvenile court in Lenawee County.
Very good.
We would
Your
also-
client has the right to admit or deny each of the allegations today, to seek placement of the children, and of course, the right to a jury trial or a trial by the bench. How would you like to proceed?
You want me to answer first?
Yes.
I cannot answer this so-called petition. I believe it's Michigan Court Rule 2.111 on pleadings that says these things are supposed to be clear and concise. This is 7 pages long, single spaced. I asked the court to at least look at this page. That is nothing that is clear and concise. I cannot sit down with my client and discuss it intelligently and get an admission or denial to a copy of War and Peace. Most of what's in this thing is not even admissible because it's hearsay. If Sarah Harvey intends to write these petitions herself, she has got to comply with the court rules. That isn't even in the ballpark of what a complaint is supposed to be like. I can't answer it. She cannot respond to it.
It does seem as though there may be some difficulty, Ms. Thomas, with this particular petition, given the density of some of the paragraphs. The one that Mr. Brooks held up is really, you couldn't probably see it from where you're sitting, but one paragraph alone took up more than 50% of the space on the page.
It's paragraph 7B.
Okay. So I think the question is, as far as admissions and denials, I would have to potentially go sentence by sentence rather than line by line. Oh, another question that he's answering. Would you like me to read this into the record?
Your Honor, I just want to clarify, we've already had a preliminary. We are here today for a pretrial and an order of an entering disposition. And the
I could
petitions
do
are.
that if I had, excuse me.
I'm sorry. I thought we had a new petition too.
That was the one that we're here for pretrial and dispo.
Number 8.
I could do that with a pleading that follows the court rules. This doesn't.
All right. Hang on, let me look at the file. We have had a prelim on, our initial prelim, I should say, was September 8th. Yes, thank you. The children were placed with Aaron Foote, and Ms. Pam Foote was required to vacate the premises, but we do not have an answer on, oh, here we are. So father wishes to plead, but due to time constraints, we're taking up a pretrial. Jury trial request, if mother wishes to have one, must be filed within 14 days. But I think potentially we still would have the same issue as it relates to whether or not she decides to admit or deny the allegations in the petition for purposes of plea. Do you-
Your Honor, I have a file that's full of nothing but words. Words, 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 words. My client's response to this is words, 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 and more words. I don't know what her position is other than she doesn't feel she's done anything wrong. So I guess I'm asking for a trial.
All right.
But this is not a properly drafted pleading.
My instinct on this, counselors, would be to allow Mr. McFarland's client to enter his plea today, if you wish to do so, and to give you, Ms. Thomas, and you, Mr. Brooks, some time to look at the petition if you want it, and we'll set for trial and another pretrial as it relates to Ms. Foote.
I don't think I should be burdened with having to go through all of this stuff with my client. I mean, it's take hours and hours to do. Clear and concise allegations. That's not a hard standard to understand.
Well, I'm not sure that that court rule in particular applies to our cases. If you want to refer to the court rules about the application of other court rules in these types of cases, we can do that. Also, there's just the practical factor that our petitions are heard on an emergency basis, and oftentimes we're asking for ex parte relief. There needs to be sufficient wording and allegations for the court to be able to make a preliminary inquiry and an informed decision as to whether removal is appropriate or not. So we've gone through this several times, and I'm happy to look at it. But when we're trying to get the point across, it's often better to leave it as wordy, I guess, as it seems. So I'll leave it at that.
I'm sympathetic to the I'm sorry.
No,
I'm
that's,
sympathetic to the explanation that Ms. Thomas is giving us. But the flip side of it is it has to be in some manageable format that I can respond to effectively and accurately with the court. And I can't do it with this case. It's too much.
Well, why don't we table that for a few minutes? We'll come back to that, Mr. Brooks, because I think I'd like to have a sidebar on that issue, frankly.
Okay.
And see what we can do to accomplish some progress as it relates to Mr. McFarland's
Do you
client.
wish us to leave the room while the sidebar or no? Okay.
Let's take care of Mr. McFarland's client, and we'll come back to yours. All right, Deputy Ames, would you swear in Mr. Foote, please?
So you're going to remain where he's at, Your Honor?
Yeah, that's fine.
Raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Foote, is it true that you wish to enter a plea, which means that you'll be admitting to some of the allegations of the petition and submitting to the jurisdiction and supervision of the court?
Yes.
Ms. Heiss, do you find that to be service in the best interest of the children?
I do, thank you.
All right, very good.
If the court would like, I can point out the specific paragraphs that apply to my client, which he wishes to make admission to.
Yes, please.
Paragraphs 1 through 4. Paragraph 13. Paragraph 17, 18, 19, 20, in parentheses A, 21, in parentheses A.
Jurisdiction and venue. 13 refers to a CTAC assessment. A recommendation to attend trauma-focused cognitive behavioral therapies. Recommendation for parents to attend therapy. Okay, Aaron Foot has not attended therapy. Is that essentially and that neither Aaron nor Pamela attended trauma-focused psychoeducation? Is that effectively the pieces of that paragraph that?
It is, Your Honor.
Okay, 17. Okay, which section of this paragraph?
Your Honor, my screen. Fresh. Aaron Foot has shown progress, but reports that Pamela Foot is a barrier to engaging in services and change in parenting styles for the family. The last sentence, Your Honor.
17?
Yes, Your Honor.
It's the very bottom line, Your Honor.
At the bottom of page 4.
So that's not really about your client, however.
Mr. McFarland, this is the one that we amended to add a separate sentence.
Take a look.
There's a sentence that says, as of 9/5/23, the family is no longer engaged in services through IHT, parenting classes, families first, or parental counseling.
Yes, that's correct. I did discuss that with my client, Your Honor.
And where is this?
This is paragraph 17, line 1, I think line 5.
1, 2, 3, 4, 5. Mine says the last home visit by a provider.
Okay, the sentence just before that one. All right, here's another one that could potentially be something I would consider. On 8/7/23, the home was in an unsanitary and unsafe condition for the children.
I had discussed that with my client. He does agree with that, Your Honor.
Safety concerns which were previously discussed were no longer being addressed.
That is correct. That's principally the locked door.
Paragraph 18. Okay, so this basically just indicates that your client is capable of appropriate safety planning and shows an understanding of how to utilize natural supports to help assist him. I mean, I can consider that, but it wouldn't be a reason for me to take jurisdiction.
I understand. My understanding is that the attorney for the agency and the guardian ad litem suggested those. I've gone over with my client, who agreed with having the court read those and along with the others for my client's plea, the totality of the circumstances.
Very good. Paragraph 19 relays information about the prior contacts. Do we know whether or not these were substantiated allegations?
My client has not denied accuracy of the allegations, Your Honor.
Okay. 20A essentially indicates the statutory authority. Essentially acknowledging because of the condition of the house and the lack of mental health services that constitutes neglect or refusal to provide proper or necessary supports, medical or other care necessary.
That's accurate.
And releasing the children to your client. Okay. All right. Well, Mr. Foote, do you understand the terms of your plea?
Yes.
So the information that I just summarized will be what I will be asked to consider. Is that what you understand?
Yes.
If I accept your plea, you are giving up the right to a trial by judge or a trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I just indicated to you if you enter a plea?
Yes.
With regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the child or children in the reasonably foreseeable future, the court could terminate your parental rights. With regard to the plea itself, the plea can also later be used as evidence in the proceeding to terminate your parental rights. Do you understand the consequences of your plea, Mr. Foote?
Yes.
Do you have any questions about any of the information I've given you so far?
No.
Okay, is anyone making you admit to the allegations in the petition?
No.
Has anyone threatened you in order to get you to admit the allegations in the petition?
No.
Outside the terms of the plea agreement, has anyone promised you anything to get you to enter a plea?
No.
Okay. Are you under the influence of drugs, alcohol, or any other mental or physical condition that could get in the way of you understanding what you're doing right now?
Nope.
Would you say your decision to enter a plea is one you made of your own free will?
Yes.
Very good. All right. So it is your position then to admit essentially verbatim the allegations that I outlined when we were exploring the terms of the plea agreement. Is that right?
Yes.
Did you want to articulate anything additional for the factual basis of the plea, Ms. Thomas?
No, Your Honor.
Mr. McFarland?
No, thank you.
Ms. Heiss? Okay, well, while you're answering that, I also have to ask everyone if they're satisfied with the advice of rights.
I am, and I've also gone over the rights with my client independently 2 times, sir.
Okay, satisfied with the advice of rights and the factual basis of the plea, Ms. Heiss?
I am, Your Honor. Thank you.
Satisfied with the advice of rights, Ms. Thomas?
Yes, Your Honor. Thank you.
Thank you, very good. The court is also satisfied with the factual basis of the plea, finding that one or more of the allegations in the petition can be assumed to be correct, as requested by Mr. Foote for me to acknowledge, including the failure to engage in therapy for himself, as well as for therapy and services for his children that were recommended by professionals that were employed in the prior case. He admits that he's also avoided trauma-focused psychoeducation, which has to do with parenting. Many of the other services that were in place have been neglected, such as Families First, parenting classes, parental counseling, and the home itself has been found to be in an unsanitary and unsafe condition with safety concerns. I do find that that is a violation of MCL 712A.13A. Or no, I'm sorry, 712A.2B1, as previously articulated, where we have a neglect in those areas that the court's already articulated. I also find further that the plea is knowingly, understandably, and voluntarily made with a full understanding of the consequences. At our last juncture, I requested that a case services plan be circulated ahead of time so the family could consider what services may be employed and consider whether or not they wanted to waive the 28-day entry into case services plan for purposes of monitoring towards.
Your Honor, it's our position, we'd like the court to adopt the case service plan today.
Right, do you have a proposed signed case services plan?
Yes. I believe it's the worker is in possession of that.
Yes, I do have a signed one from your client. You're satisfied that the copy you have reflects what I have?
Yes, Your Honor.
Very good. All right, Mr. Foote, you would typically have 28 days to look at this before it becomes a court order. Do you want me to make this a court order today rather than allowing you that 28-day time frame to look at this?
Yes.
Any objections, Ms. Thomas, to the waiver?
No, Your Honor.
Ms. Heiss, do you find this to be appropriate and in the best interest of the children and legally sound?
Yes.
All right. I think you'll find, Mr. Brooks, the case services plans are rather succinct and targeted at the challenges that have been identified in the petition and in the plea. So I am happy to adopt that. For purposes of disposition as it relates to Mr. Aaron Foote, then Ms. Thomas.
I would call Ms. Pelham to give her report and then testify on the disposition.
All right, Ms. Pelham-Reeve, come on up to our witness stand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, could you give us your preference? I'm happy to say your entire name every time if you wish. If you have a preference, I'll be happy to take that into account as well.
I go by Pelham Reeve, that's perfectly fine.
Very good. Okay. Ms. Thomas? Yeah, you're a witness.
Chelsea, how are you involved in this matter?
I am the ongoing worker.
And as the ongoing worker, have you prepared a case service plan for Mr. Foote?
I have.
And currently, what is the, I guess, permanency goal for these children?
Reunification.
And the children have remained in the home with Mr. Foote, correct?
I have, yes.
And when you created the case service plan, were you able to discuss it with Mr. Foote?
Yes, we were able to talk about it.
And did he have an opportunity to provide input as to what he thought was, or what services he might need to address the conditions that caused the court to take jurisdiction today?
Yes, he did have an input, but he agreed with everything that we had started with, so.
And do you believe that as presented today, those, the case service plan is tailored to meet his needs and address those concerns?
Absolutely.
And prior to today, had Mr. Foote engaged in any voluntary services?
Yes, he has actually worked with Families First, and he started his own primary counseling through, I believe, Blue Cross Network. It's just someone through his insurance.
And prior to today, has he been cooperative with the department?
Absolutely.
And generally speaking, how are the children doing since the, I guess, the change in the home environment?
Overall, the kids seem to be doing really well. They're benefiting from, I think, this break from their mother. There have been some mishaps here and there. I know that Mikey did run away from school on Thursday, I believe, but Mr. Foote was very appropriate about his response to that. A couple of the other kiddos had some random, illnesses, stuff like that. He's been very appropriate about getting them medical care as well.
And because the children are placed with him, there is no recommendation for parenting time or anything like that, correct?
Correct.
And is there anything that you would like to report to the court today or highlight from your court report or the case service plan or any of the attachments?
Not for Mr. Foote.
And just because you are on the stand for purposes of review and just giving the court an update, can you please, is there anything else you'd like to highlight about the children's progress or how things are going?
The children, we have kind of utilized all of Mr. Foote's natural supports, and they each have another adult that they can report to with any concerns. The two littlest are staying with those supports during the week, and they're doing really, really well there. The kiddos, Madison specifically, I spoke with her school counselor, Miss Carla Fisher, and that was about a week after Pam's removal, and the counselor.
Refrain from children's names.
Yes,
I apologize, sorry. Her counselor did report that she is thriving even that soon after the removal.
Thank you. All right, I have no further questions, Your Honor. Thank you. And move to admit the court report in the proposed case service plan that has been signed by Mr. Foote.
No objections.
I have a question. May I ask it?
Yes.
Did you contribute to the content of this petition?
No, I did not.
Thank you. That's all.
I have no objection.
All right, the court report is received, as well as a proposed case services plan for Ms. Foote and the case services plan for Mr. Aaron Foote. Any questions, Mr. McFarland?
Is there any priority that my client needs to focus on?
Right now, we are focusing a lot on getting the kiddos into therapy themselves and doctor's appointments and stuff like that. But he's pretty aware of that and working really well with us on getting all that figured out.
Nothing further, Your Honor.
Ms. Heiss, any questions?
Briefly, thank you. Did you say that 2 of the children are spending 5 overnights per week out of the father's care?
Yes, they are with another caretaker during the week time.
When did you know that the oldest boy had been suspended from school?
I actually just found that out yesterday.
Okay, but the father knew earlier, is that true?
As far as I know, but it is important to know I was off work last week, Thursday and Friday, so he didn't have a way to contact me.
Who was there when you weren't?
Miss Harvey and Miss Grant.
Do you know if they had a report about the suspension?
I don't believe that they did.
So in response to that child, part of the risk that brought us into care was some of his behavior, is that true?
Yes.
And then the continuing suspension, will he be referred for a Maximus evaluation?
We cannot refer anyone for Maximus until they're removed.
Do you mean he won't get a Maximus assessment because he's placed with dad?
Yes, he's not in foster care technically.
The voluntary service, the case service plan for Miss Foote, at this point, it would be a voluntary service plan, correct?
Correct.
And she has looked at it, but she didn't sign it, correct?
Correct. We had a meeting about it and she told me the information that she did not want to do, and I noted that.
Okay, and then you agree that she can participate in the children's medical care. She's not to interfere, but she can participate. Is that true?
I do not believe it's a good idea for her to attend physically to appointments due to the court order saying supervised visits, and people who are helping take kids to appointments do not want to supervise those. However, she does have access to all the apps where she can get after appointment summaries and all of the information. And I will also tell her anything that I know as well.
So you're not willing to let her participate virtually in doctor's appointments?
If it is with someone who is willing to do that, I just don't want to force natural supports to have to participate with her, as in the last case that kind of ruined those natural supports. So we want to ensure that they feel safe as well.
You must admit mom knows more about the medical situation if she could communicate effectively, true?
Absolutely, but there are concerns about the things that she does say at doctor's appointments and the truthfulness behind all of them with kids' behaviors.
What is the policy that guides when a child is placed in home? What is the guidance for medical help? Is it if one parent is involved, that's sufficient, or do both legal parents have right to participate?
So I did reach out to management and our attorney, Ms. Thomas, to get an answer on that. I think all of us are kind of confused and we all don't really know what the answer is to that. So I think we need guidance on that today.
Well, in the meantime, though, just to make sure that a child doesn't get therapy that's contrary to an allergy or something, would you be willing to allow her to participate in medical services for the children?
I can't say that I am, because if family support doesn't want to have her involved and does not value that relationship with her and does not feel safe with her, I don't want to force them to do that.
Thank you. I have nothing further.
All right, any redirect?
No, Your Honor.
No recross.
Any other questions, Mr. Brooks?
I do not.
Thank you for your testimony.
Thank
You
you.
may return to your seat. Anyone else you'd like to hear from today, Ms. Thomas?
No, Your Honor.
Okay, Mr. McFarland,
No.
Ms. Heiss?
No witnesses today. Thank you.
Comments as it relates to the adjudication and disposition of Mr. Foote, Ms. Thomas?
None, Your Honor.
We just asked for a normal review date, Your Honor.
Ms. Heiss?
Yes, Your Honor. I just would like to have us keep our focus on supporting the health and safety of the oldest child. It was my understanding that we were going to look into supporting him so that the that issue for the other children in the home was going to be resolved too. I see that we're at a standstill on that at this time, but it was I think important to continue to watch that piece. I think he also has a juvenile case that this court is watching him also, but I don't see stabilization for him yet, but we'll continue to look for that. Thank you. I have visited with 3 of the children and intend to visit the others soon. Thank you.
Well, the court finds all interested parties were given notice and that Mr. Foote waived notice on the disposition hearing, requesting the court to enter that order today with the case services plan, which will be monitored moving forward to track his progress. The children are placed with him. That is the safest and least restrictive measure at this time, although clearly it is perhaps raising some interesting questions on the services available to the youngest child, but given that there is or not oldest child, there's also a companion delinquency file. So perhaps services can be explored through that file as well to meet those specific needs for him and for the other children. But I do find all parties were given copies of all of the documents for today as well, and that the case services plan is targeted towards the areas that Mr. Foote agrees needs some work, and that will be, again, reviewed every 90 days. The restriction of the mother remaining outside of the home will remain. We will continue into a pretrial for her in a few minutes, and we'll continue to, I'll hear any more additional arguments on that, but for purposes of the adjudication and disposition of Mr. Foote, that will be the continuing order of the court. Reasonable efforts are being made towards the goal of reunification that was articulated by Ms. Pelham-Reeve, as well as received in better detail in the court report, as well as Ms. Heiss is in satisfaction of her obligations as well. We'll have our first regular review for Mr. Foote on December 19th. Does it matter what time we set that?
Oh, mornings work better for me because I can just go into work late.
Is 9 a.m.?
Yes, that works.
So we'll set this review then for 9 a.m. Tuesday, December 19th. All right, so that will conclude the matters as it relates to Mr. Foote.
I have
As it
my
relates,
client wait out in the hall for the order.
you may, yep,
Thank you.
you're welcome. All right, so as it relates to the pretrial, Mr. Brooks, you wish to have the court set a trial date?
Yes.
Very good. Just a reminder, if you wish to exercise your right to a jury trial, Ms. Foote, you'll have to talk to Mr. Brooks about that. Thank you. And make sure that that request is made in writing within 14 days.
We've covered the subject and she has told me, and I've asked her to confirm it, that she is not asking for a jury trial. But I would like her on the record to confirm that.
All right, Ms. Foote, would you mind moving to the other side of your attorney so that we can have you a little closer to that microphone, please? Watch your head. Yes, watch your head. Giant TV monitor. Right there. Deputy Andrews, would you please turn her in?
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Brooks.
Now, I've asked you off the record whether you want a jury trial or a trial by the court. What is your answer?
Trial
Would you tell the judge that?
by, trial by court.
Okay,
Thank you. That's all.
all right. All right, would you like to be heard on anything today for purposes of what we're doing between now and when we come back for trial and visitation, the order requiring your client to remain outside the home, any of those issues?
I do.
Go ahead.
Coincidentally, Your Honor, this month's State Bar Journal, Michigan State Bar Journal, has an article covering the unauthorized practice of law. According to the article, I have the obligation to file a formal complaint with the Michigan Supreme Court against anyone I think is guilty of doing that. Now, I know that the drum I'm beating has been well worn by me in the past in front of you. But there's a reason. It's because the people who are drafting these monstrosities of a petition don't even know what a court rule is, have no idea what the limitations on pleadings are, and as a result, leave it up to me as the defense attorney to somehow sort out the crap from the substantive allegations and present you with a response that allows the efficient administration of justice in this court. As I've said to you before, I can't. I do. Once I've got Ms. Harvey on the stand to ask her if she wrote this thing. I wish she was here today and I would ask her. But once I have had her on the stand to ask that, it is my intention to file a complaint with the Michigan Supreme Court accusing her of the unauthorized practice of law for filing pleadings that are clearly not written by anyone who has the remotest idea of what she's supposed to be doing. And asking that action be taken to stop it in the future. So I don't even know if you should be proceeding with this until I have the opportunity to ask her that very question under oath. I'm not going to do it today because I have no sworn testimony that establishes that she wrote this. But I am pretty sure she's not a lawyer. And I know of no exception under the court rules on pleadings that say, except in the cases of abuse and neglect, you got to follow the court rules. I don't think that exception exists. You got to follow the court rules. It's obvious to me that whoever wrote this has no idea what a court rule even is.
Right, I would be happy to provide you a jury trial, or I'm sorry, a bench trial date as soon as possible. Looking at the calendar now, here we have the morning of Monday, November 6th. Have that any of our main attorneys would be out that day. Please correct me if I'm wrong.
I'm all set for that day.
Your Honor, I will not been able to put it on our calendar, but I will be out from November 5th through the 10th.
Okay.
And to say that I will be available, but for purposes of a trial, I would prefer to be in person. And I would only be able to Zoom in.
Okay. Well, if you're going to be back. Well, I have a jury, not a jury, yeah, it is a jury trial. I could put you as a backup. On. Friday the 3rd, or schedule it in the afternoon,
I'm sorry, the date again?
would be November 3rd in the afternoon, but I don't know if that'll work either, because if that jury trial goes, what is your sense on that, Ms. Thomas?
I have not heard at all, but if it does go, I would not anticipate it to go for the full 2 days. So if we set it for the afternoon, I think that would maybe be safe.
Okay. I mean, I just found, okay, so we have another option for, one more option for the afternoon of the 27th of October.
I
I'm available.
anticipate calling one witness.
So,
I'm available.
October, okay, Friday, October 27th at 1 o'clock. Let's do that.
We are in I am in an adjudication trial in Anzalone's court starting at 9 a.m. that day. Do you think I can't say that I'd be clear. I think I would be, but would you rather set a different date or?
Those things, those probate cases in front of Judge Anzalone typically have to sit and wait behind half a dozen criminal and other matters before she even gets to those things.
And that's
So
Mr. Brooks's case, Espinoza.
No, that will not be done in less than a day.
Sorry, Your Honor.
Well,
Thank you.
it's good to have that information. Okay, so let's go back to the drawing board. Ms. Thomas, do you think we should schedule a full day for this?
I think it might be safe. I don't know that we'll actually need it, but I know that it would probably be safe.
What would the court's position be if once I ask my question of Ms. Harvey, and as I anticipate, she answers it in the affirmative, that she drafted this legal pleading, which is now part of the official court record? What is the court's position when I advise the court that I intend to file a complaint against her for the unauthorized practice of the law? Because that's what's going to happen.
I appreciate what you're asking me, Mr. Brooks, but my priority is to the children in the file. So I would, of course, not do anything to get in the way of what you need to do, but we would have to move forward with our proceedings regardless.
Thank you.
I can put you as a backup to the jury trial on Heron, Tuesday, December 5th. Otherwise, the next.
I was gonna say, I think that that's probably a really safe one, given what just transpired in that case.
Okay. So 9 o'clock, Tuesday, December 5th.
Nine o'clock on December 5th, 2023.
Yes. And I will have this marked off for the entire day, Mr. Brooks. So I would ask you to do the same to make sure that we can get through it if we need it.
I will again, my only witness is going to be my client. What I have to demonstrate can only be demonstrated through her.
All right, very well. Anything else you'd like addressed today for purposes of pre-trial?
No,
Ms. Thomas?
I just will say for the record, I don't take lightly the threat of claiming one of the DHS workers is engaged in the unauthorized practice of law. If Mr. Brooks were familiar with the court rules, starting in chapter 3.900 as it relates to special proceedings, we do have to follow the conformity of pleadings as identified in the court rule of MCR 1.108 or in 109. Ms. Harvey has in every worker, the allegation essentially amounts to every worker engaging in unauthorized practice of law. So if someone doesn't know what they're doing, that allegation is against me for signing onto it. Ms. Harvey's signature is her claim and affirming that she is familiar with those allegations, just as every other worker in these types of cases. So I don't.
Non-lawyers cannot write legal pleadings. That's it.
Mr. Brooks, Ms. Thomas is just, I think, making a record.
Correct.
And I'd be happy again to address this in a bench conference in a sidebar, and I will ask all the attorneys to hang on after we're finished for that purpose. But we're going to let Ms. Thomas say her piece for the record.
Your Honor, and I believe that was most appropriate, and that's where I thought that we were going to address this until it became a issue on the record. But with that, I have nothing further for purposes of pretrial. But Judge, I just would ask that on the order after today's pretrial, scheduling order or the dates for all of the good stuff like discovery exchange and whatnot, just be delineated so that we are all on the same page on that.
Okay, what would you request? I typically would say witnesses and exhibits have to be filed and exchanged no less than 7 days ahead of time.
That's totally fine. Yeah.
So I'll include that. Anything, Ms. Heiss?
No, thank you.
All right, well, we've got our trial date set. All prior orders of the court will remain in full force and effect, including the placement of all children with Aaron Foote and the removal order of Ms. Pam Foote to be out of the home with supervised parenting time with the discretion and organization of the Department of Health and Human Services. Ms. Foote is always welcome to engage in voluntary services, and we'll continue to expect Ms. Ellen Reeve to be accommodating for any services that she may want to engage in prior to adjudication. Witness and exhibit list will be due to be filed and exchanged no later than 7 days prior to the trial date that we've established. The placement of the children is the safest and least restrictive under the circumstances for all the reasons that were articulated in the initial petition and that remain unresolved as of today. Unless there's any questions, that's all for now.